Mr. President, I'm here for the 147th time in my series of speeches urging the Senate to both wake up to the consequences of climate change and also to the motives of the outside forces that lull the Senate into persistent somnambulism. Outside this chamber, every major scientific society, every one that I know of my colleagues' home state universities, all of America's national labs, our military and security professionals, NOAA and NASA, all agree on the basic science of climate change and broadly support responsible climate action. There may be uncertainty about exactly what year sea level rise will hit what flood mark, for instance, but on the basic idea that climate change is causing seas to rise and floods to come, it's game over. NASA reported August 2016 was the warmest August in 136 years of record keeping. August tied July as the hottest month the world has seen in the 136 years we've been measuring. More notable, August marked the 11th record-setting month in a row in NASA's dataset. Why, in the face of all of that, does this chamber slumber? Thank the dark influence of the fossil fuel industry. For years, big oil and its allies funded outright denial of man-made climate change. The Union of Concerned Scientists issued this report last year. Climate Deception Dossiers. Internal fossil fuel industry memos reveal decades of corporate disinformation. The report documents how the big polluters contributed to front organizations and paid scientists to put out junk science, contradicting what real peer-reviewed science and even the industry's own experts knew about how burning fossil fuels affects the environment. Take ExxonMobil, for example. According to the company's own documents, as recently as 2015, ExxonMobil was still funding organizations that promote climate science disinformation, including the American Legislative Exchange Council, which peddled legislation to state legislatures that included a finding that human-induced global warming, quote, may lead to possibly beneficial climatic changes. The Hoover Institution, where a senior fellow, not a climate scientist, argued that climate data since 1880 supports the conclusion that it would take as long as 500 years to reach a 4 degrees centigrade of global warming. The Manhattan Institute of Policy Research, where a senior fellow writing about climate change said, the science is not settled, not by a long shot. The so-called National Black Chamber of Commerce, whose CEO has claimed that there has been no global warming detected for the last 18 years. Tell that to NASA. And let's not forget the Pacific Legal Foundation, where a senior attorney attacked EPA's authority to even regulate CO2, in part because it is a ubiquitous natural substance essential to life on Earth. All of those pronouncements by Exxon-backed organizations, as reports in both Inside Climate News and the Los Angeles Times have confirmed, run counter to what real scientists know. Yet, according to the public affairs guy at ExxonMobil, the company has supported mainstream climate science for decades. Frankly, we made the call, their PR guy said, that we need to back away from supporting the groups that were undercutting the actual risk of climate change. Well, that doesn't actually seem to be true. ExxonMobil's campaign of falsehoods has the attention of several attorneys general, and in today's newspaper, it reveals that it also has the attention of the Securities and Exchange Commission. Their questions are not unreasonable. Does ExxonMobil actively advancing the notion that its products have little or no effect on the Earth's environment, while at the same time suppressing its own internal research on the effects of carbon pollution, deceive consumers into buying ExxonMobil products based on false claims? Is the company misleading its investors about its developable oil reserves and long-term prospects in a climate-changed world? It breaks the law to knowingly mislead consumers and shareholders about something material, and climate change is certainly material to ExxonMobil. As Senator Warren and I recently wrote in the Washington Post, investigations by state attorneys general are making ExxonMobil nervous, and their Republican friends in Congress are riding to the rescue. House Science, Space, and Technology Committee Chairman Lamar Smith and his fellow committee Republicans have issued subpoenas demanding that the Attorney Generals fork over all materials relating to their investigations. I asked the Congressional Research Service, and as far as they could find, no committee has ever subpoenaed documents in an ongoing state AG investigation. Setting aside the federalism problem of Congress going after states in a sovereign state function, if they tried this stuff with our federal attorney general, they'd be rebuffed. The committee subpoenas also targeted 8 organizations, including the Union of Concerned Scientists and the Rockefeller Family Fund and Greenpeace, ordering them to turn over their internal communications related to what Chairman Smith describes as, quote, coordinated efforts to deprive ExxonMobil of its First Amendment rights. Take a moment to absorb that. State attorneys general are investigating whether a fraud has been committed, something state AGs do every day. As Rhode Island's AG, that's what I did. Sometimes we'd uncover fraud and sometimes not. And ultimately, if the evidence warranted it, and if the Attorney General pursued the case to trial, the question of fraud would be resolved in open court. Instead of praising the state AGs for doing their jobs within our system of checks and balances, congressional Republicans have leapt in to obstruct the investigation before any evidence becomes public. So far, both the subpoenaed attorneys general and the 8 organizations have refused to comply with those subpoenas. I say good for them. If the committee moves to enforce its subpoenas, the matter will then come before a judge. If that happens, I hope those attorneys general will question whether the committee subpoenas reflect a legitimate governmental effort or are issued on behalf of a private party. Indeed, the very private party which is the subject of those attorney general investigations. The law is clear that a legislative committee may pursue even an unworthy legislative purpose, but it is not clear that a legislative committee can lend itself to a private party. Let the court determine whether the House committee is acting as the de facto agent of ExxonMobil. What might that court consider? Well, first, this is a committee whose chairman has received nearly $685,000 in campaign contributions since 1989 from the oil and gas industry. The remaining committee majority have received over $2.9 million in campaign contributions. I expect that's admissible evidence. What else might the court consider? Well, the committee asserts ExxonMobil has a First Amendment right here that it needs to step in to protect. Interestingly, the shoe has been on the other foot when an attorney general of Virginia was tormenting a climate scientist. Indeed, tormenting him so badly that the University of Virginia took that attorney general all the way to the Virginia Supreme Court to make him stop. The committee took no interest in that. Theirs is a First Amendment concern that only surfaces when the fossil fuel industry is the subject of investigation. What else might the court consider? Well, how about that the entire First Amendment argument the committee makes is a crock? Ken Kimmel, the president of the Union of Concerned Scientists, noted that the committee makes no allegation that the Union of Concerned Scientists violated any laws or regulations, and the claim that providing information to attorneys general infringes on ExxonMobil's rights is nonsense. End quote. Mr. Kimmel is right. It is well-established law that there is a clear line between fraud and First Amendment protected speech. The dean of the Yale Law School has published an article explaining this, which I'd like to ask unanimous consent to append to my remarks. As the Attorney General of New York correctly states, fraud is not protected by the First Amendment. A number of high-profile legal scholars sent a letter last week to Chairman Smith condemning the subpoenas as misguided. The letter argues that the subpoenas are invalid and constitutionally impermissible. It turns out, according to these scholars, that the First Amendment actually works the other way. Quoting them here, the subpoenas and the threat of future sanctions themselves threaten the First Amendment, wrote these scholars, directly inhibiting the rights of their recipients to speak, to associate, and to petition state officials without interference from Congress. End quote. I ask unanimous consent to enter into the record a copy of the legal scholar's letter to Chairman Smith.
Without objection.
Rhode Island Attorney General Peter Kilmartin and 10 of his colleagues have also urged Chairman Smith to withdraw the subpoenas. Your interference in our colleagues' work, they wrote, ignores a vital consideration under our constitutional system of dual sovereignty, the preservation of comity between the federal government and the states. End quote. I ask unanimous consent to enter into the record a copy of the Attorney General's letter to Chairman Smith.
Without objection.
Mr. President, congressional investigations and hearings have a unique ability to focus a nation's attention and to bring facts of public importance to light. These subpoenas, however, appear intended to impede lawful state investigations. They do not advance the First Amendment, they trample on it. Senator Warren and I offered a suggestion to the House committee in our Washington Post piece. If this committee is so concerned about the First Amendment rights of ExxonMobil, call a hearing. Invite ExxonMobil executives to testify and give them the opportunity to speak freely. What better way to protect a person's right to speak freely than to give that person a forum to speak freely right here in Congress? They can come in, say whatever they want to say, and answer questions. I know I would love to hear what they have to say.